Hey guys, before I take you to today's content, I want you guys to take advantage of our Pro Web Legal Services Initiative that we have going on right now in the second quarter of 2024. What is that? Well, it's a website that you get 100% full-blown website with 1 year maintenance, comes with SSL certificate, hosting, etc., all for 50% less than the normal cost. This offer used to be $4,500. We're now giving it to you for $2,250, 100%, no strings attached. All you have to do is go to the show notes right now and click on the link where it says Pro Web Legal, and you'll get all the information. So until then, enjoy the show.
Hello and welcome to Marketing Solutions for Local Law Firms, the podcast that provides you with all the latest digital marketing tools, tips, and strategies you will need to implement in order to stay ahead of your competition. If you are looking to substantially increase your caseload in the next 6 months, this is the podcast for you. And now, here's the host of our show, the local business guy himself, Frank Deming.
Hello, everyone. This is Frank Deming, the local business guy. Welcome to another episode of Marketing Solutions for Local Law Firms. Happy Wednesday. Happy hump day, everyone. I hope you guys are having a rockin' week thus far. Today is Meet the Attorney, and I'm going to be talking about a topic that I have not talked about in quite some time. In fact, it's been since last season that we talked about this. And we're going to be talking about IP, intellectual properties, one of my favorite topics because there's not a lot of attorneys who do it. But I've got a dynamo on today who's going to teach us everything that we need to know about IP. And I'm talking about the great Anthony Verna. How's it going, Anthony?
Why, thank you, Frank. It's going well. I'm so glad you haven't overpromised on my appearance, but thank you so much for having me here.
Hey, it's a pleasure having you on. I always like to, because I understand you also have a podcast.
Yes. I
always love to interview fellow podcasters because it's always clear and crisp and everything like that. And no background noise is perfect.
That the microphone setup is important. It's not the most important. Obviously, the content is most important because there are some podcasts that I listen to where sometimes I don't know they didn't microphone setup wasn't right for that episode, or they weren't recording in their usual spot, and the sound's not that good, but the content still is. So the content matters, number one. But I tell you what, getting the right equipment feels like 1A.
It does. And my first year of doing this, I didn't have the right equipment because I didn't know if I wanted to do this.
Sure.
And once I said, hey, I kind of like this, then I continued and got the right equipment. Anyway, enough about that. Just why don't you introduce yourself? Tell the audience, who are you and what do you do?
Sure. So my name is Anthony Verna. I'm the managing partner of a small firm called Verna Law. I searched long and hard to figure out what to call the firm.
Must have been hard.
We're a 3-person intellectual property and advertising law boutique firm. So it's me. We also have a patent agent, and he is in charge, of course, of filing our patents. And we also have an attorney who is of counsel to the firm, which, means that when I need her for our litigation matters, I have her there as a double check on anything that goes out. I have her there to hear cases, make sure that our facts are solid. And she's also licensed Washington, Oregon, and California. So I'm licensed New York, New Jersey. So we have a good litigation reach for a small firm.
Awesome.
A little bit more about me. I am a full-fledged nerd. I have a bachelor's in computer science. If that doesn't tell you what kind of lawyer I am, I don't know what does. Uh,
Well, you're a lawyer who understands technology. I can tell you
that is exactly the thinking here is that I understand technology. You could even see my server flashing behind me. Like I'm so much of a nerd that I have the server, flashing there instead of, proper branding stuff. Uh
interesting. I thought it was a router. No,
yeah, no. That's my server right there. That's my
interesting.
server. Uh here's how to hack my server. No, no. Uh, let's see. Stuff for fun. I play guitar. I grew up
Mm.
playing tuba. I've had a long rest away from it though I just got mine. I just got it fixed. And I've been buzzing on my mouthpiece, or one of my mouthpieces right here, trying to get my lungs back to capacity, my head and lungs back to capacity. So I'm going to be picking that up again very soon.
Nice.
So yeah, some music's a big hobby for me as well. What else should the audience know about me?
Well, I have a question that I think they would want. Well, I know I want to know.
I'm assuming you're a proxy for the audience anyway.
Out of out of all the law practices out there, why did you select IP?
Because most of it most of it hurt my heart, to be honest with you. Like going through law school, for example, you take the family law class. Like, my snarky self was like, this is tearing apart family law class, like it's, there's, what's the old saying? How do you know lawyers are miserable people? Well, what's the first thing you do to file a lawsuit? It's called a complaint.
Yep.
We like a lot of what we do is kind of on the miserable side of life because we clash. And even, yes, I litigate as we do litigate here. But we're always searching for solutions. But regardless, like everything a lot about law school felt miserable to me. This felt intellectual property. When I took the IP survey class, I took, what did I do? I took the IP survey class, advanced problems in copyright law. My only A plus in law school was an advanced problems in copyright law. Not my only A, but my only A plus. I still can't believe law schools had A pluses, but anyway, it was advanced problems in copyright law. I obviously took patent 1 and 2. As well, there was a computer tech, a computer/tech seminar class, and I don't really know what the difference between a regular class and a seminar class was, but they called it a seminar. Anyway, I took all the tech stuff. And it felt all like an extension of me, and that's really what my practice feels like, an extension of me. Part creativity, part law, part business. Finding solutions for our clients rolled up into one. And I kind of felt as if I wouldn't be able to find that extension of me otherwise than in here. And to be honest, that is how I see as a throughput, from law school to here, is that this practice is an extension of who I am. This area is an extension of who I am.
Makes sense. Now, I've interviewed other IP attorneys, and a lot of them, for some reason, do not do litigation. They outsource that. They just select I'll patent your thing, or I'll do a trademark for you, but they don't do any litigation against someone's trying to take it from them. So why did you select to do litigation? And is it wise to have a practice that doesn't litigate?
Well, look, everyone's different. I mean, I've got a colleague who left a big firm in New York City, and every like 3 or 4 years, I kind of tap her shoulder. I'm like, hey, you want to team up here? And she doesn't. And all she does is trademark applications, and that is it. She doesn't do copyright. Call Anthony. Patent. Call Anthony. Trademark litigation. She does trademark applications, and she still has a lot of her clientele from the big firm, and it's what she wants to do, and that's it. Period. End of sentence. Now we're all a little different. I actually got a case a couple of years ago from another colleague who I don't recall how she and I met, but we met through networking. And this client found her and said, we're being sued for, copyright infringement, trademark infringement. And, she said, A, I don't litigate. B, why don't you call Anthony? Because it's kind of everything there.
Mm-hmm.
So, it's why did I choose to litigate is because A, it's a variation. Not every day is looking exactly the same for me. Some days I do need to handle, the rote paperwork of the prosecution experience, and some days I need to handle the rote paperwork of the litigation experience, and it's different because sitting down writing discovery documents and answering discovery documents is different. It's an exercise in the brain. So from a philosophical standpoint, from a personal selfish standpoint, it exercises different parts of my brain doing applications and litigating.
Mm-hmm.
But from a clientele standpoint, I hope my clients understand that when you come to us, for the applications, we litigate as well. So we can say, look, I'm forming this because I see what it's like on the other side.
Mm-hmm.
I see what happens when people don't, file correctly, or the registration is a little off, or there's some kind of, trademark registrations can go through that don't fully match the business because there's no real check there.
Got it.
Patents, because of how you draft the claims, that's not necessarily, true, but but you've got to make sure that your patents, your trademarks match up to what you actually have. So that's one particular reason
Mm-hmm.
why we do it. It's for us to give that higher, larger view approach to our clients.
Yeah. Now that's a perfect segue into my next set of questions. Just so that we're all on the same page here. I'm going to ask you three questions in succession. I just want you to just fire off and just, because they're all going to be, they're all going to be related, if you will.
So this is the lightning round.
Okay. Yeah. This is the lightning round early on in the conversation. A, what's a patent? B, what's a trademark? And C, what's a copyright? I mean, I those things have always been confusing to me. I have an idea of what they are, but if you could just educate us, if you will,
I'll do
I
my
would
best.
appreciate.
A patent is a certificate, so it's a grant from the government that allows the holder of that particular piece of paper to have a monopoly on what's described in the documentation. So here in the United States, you have an invention that is new or novel. You can apply for your patent, and once you argue with the Patent and Trademark Office, you come out with a patent on the other side. You have a monopoly, government granted monopoly, to create the product or the process that is described in the patent that you have applied for. So the patent is this government grant that says only you have the right to make this product or decide who makes this product. So you can license it, of course.
So it's something that's done prior for it being in existence. That's what I'm hearing. So you patent something before you actually have it in the market. Is that what I'm hearing?
Well, I hope that you start filing before it's in the market.
Gotcha.
But that's actually a very good question. Should you disclose your new and novel invention publicly? And that public disclosure could be to a friend. That happens. It could be at a trade show, and that happens. Or it could be putting it up for sale. That happens as well. In the United States, you have 1 year from the date of that public disclosure to get your patent application into the Patent and Trademark Office. So, yes, I want you to do it before you put it on the market. That said, you have a little wiggle room should you fudge that.
And is a patent something? When you patent something, that's something that's tangible, or can it be software?
A patent can protect software because it can protect algorithms. So it doesn't protect the code. It protects the steps in the software, provided, again, that the software is new, novel. And thank you to the Supreme Court for screwing this up. It has an inventive step. Now, where did that come from? It's a case, and I could sit here and talk about the case. I'm not going to because I don't want to bore people. But effectively, the Supreme Court added this phrasing, an inventive step, to software algorithms, methods, those kinds of patents. Yes.
So in other words, sorry to cut you off.
No, that's fine.
Google has patented their algorithm.
Or algorithms. Sure. I would
I'm sure
assume
Facebook has patented their algorithm.
Sure. I mean, look, one of the biggest patent infringement suits that there was about Amazon creating, getting a patent on its quote unquote one click, ability to purchase. And there are a lot of people very critical of the fact that it's like, well, it's just one, like what's new, novel, inventive about this? I mean, it's one click, but like all the information is already saved on the website, whether or not it's one click or two clicks or whatever. Like all you're doing is saving the information on the website, and there's nothing, is particularly inventive about the fact that, all right, it's all saved. Then I click once and then it's purchased. But that was one of the bigger, suits around because, a lot of people said, no, this isn't new, novel, and inventive, and made their own. And so there is, gigantic litigation around that. So yeah, I mean, like I said, it's about the method and the steps. And let me tell you, every company that's creating software is going to be filing patents on their algorithms. Doesn't matter if it's Google, Microsoft, even IBM. To this day, IBM is still the number one filer of patents in the United States.
Wow.
So you're going to have to play with the big boys, but method patents exist. And if you have something that is new, novel, inventive, you got to get that application out the door.
We'll be back after a quick break.
Hey guys, I hope you guys are enjoying today's content. While I have you on here, I want to introduce you to a promo that we have going on for the spring of 2024 for all legal practices throughout the U.S. I have an outstanding offer that we've never been able to offer before, but we want to do it because you have been an avid listener. We're only promoting this to people who listen to the show. So if you're an attorney and you are an avid listener to the show and you're thinking about possibly opening your own practice, you want to pay attention to this announcement. We are offering a full website with hosting, SSL certificate, online booking service, online appointment management, and more, and much, much more, with a 1-year maintenance, all for $2,250. That's $2,250 one-time fee, and you have a full-fledged website. If you want to know more about this, just give us a call at 888-416-7752 or send us an email at info@lbmsllc.com. Just make sure that you mentioned that you heard it on the show, and we'll definitely get you that discount. So with that, I'm going to bring you back to the content. So if I have a process, let's say, or a method,
yes,
of the way I do business,
yes,
I patent it or do I trademark?
You could. No, that's a patent.
That's a patent.
That's a patent. Patents protect inventions. And whether that invention is a thing that's tangible or something that, is not necessary, or is a process or a method that's a little on the intangible side, it still is protectable. So now you asked, what is a trademark? Trademark law is an area of law that protects branding and only branding. So
perfect.
I take my product, I put a label on it as to the company that makes it. That is the brand, right? I got some Avery brand labels, here next to me, for my mailings. There's an R in the circle next to Avery. The brand is a registered trademark, and that's really what trademark law protects: the branding. Now, sometimes we could talk about colors. Sometimes we could talk about trademarks that are not traditional. So sometimes we talk about sound trademarks, maybe. And I'd say, a sung jingle, like if you think of the Red Robin commercial, where they go Red Robin Yum at the end, like that little, sound bit, those notes are probably a sound trademark of the restaurant chain. But
I also heard that Play-Doh trademarked their scent, or was that a patent?
that would be a trademark registration, because the scent, I mean, it could be both, but it could be because you could probably have registered the method for creating that particular scent if
Got
there's
it.
something, chemical about it. But from a standpoint of, I open this, I smell that aroma.
Mm-hmm.
It is possible. I will be honest. I don't have a memorization of all of the non-traditional trademarks that are out there, but
Mm-hmm.
a scent trademark like that is possible. Is possible under the act that the laws that we have. And so, yeah, I mean, that's a very plausible thought that scent is a registered trademark for Play-Doh.
Interesting. Wow. That is fascinating to me.
But trademarks, patents are about brands. Patents are about inventions. Trademarks are about brands.
Got
Then
it.
copyrights. Copyright is traditionally about works of art.
Hmm.
Yes. So I could create, photographs. I could create, a 2D visual work like a painting. I could create a 3D visual work like a sculpture. I could create audio visual work. So, movies, TV shows, any video that you see on the web, music,
Hmm.
whether it's the actual written sheet music or whether it's the sound recordings. Architectural works, meaning the blueprints, should it be, unique enough. Um,
Yeah.
Choreographic works are filed under copyright law as well. So if you're a choreographer, everything that you do has to be considered just as if you were a painter.
Hmm.
That's what copyright law protects. It's again, it's a grant from the government that says you have a monopoly on the work that's in the copyright certificate, and you're the one that can control who makes it, who publicly performs it, how it's licensed, how it's used, control over what we call derivative works. In
Mhm.
other words, works that fall under copyright law that might be derived from yours. You have the right to control that as the original owner. But that's what copyright law is. Copyright is that grant for artwork traditionally. Now, in today's world, we shove software into copyright law. And when I
Okay.
say software, now I'm talking about the actual code.
The code, right?
Right. Now, so clients call me and they say, all right, I've got software. Do I need a copyright? Do I need a patent? And the short answer is could be both. Could be both. You have to understand from a software standpoint what that's going to protect. Filing a copyright in the software is, helpful. It's a
Mhm.
limited protection because it's about the code that's written. If somebody, is able to create similar software, but they did it independently, your copyright protection is not going to, not going to help. If somebody were to deconstruct your code and create it, different story. If somebody is
Mhm.
pirating your software, that's a different story. Copyright law. Copyright law. If somebody creates software independently of yours, again, that goes to patent law because now you're talking about if the steps
Mm.
are protected or not.
You have to
Copyright law protects the actual work.
you have to prove all of that though, right?
Well, sure. That's a different story.
That's the hard part.
That's a podcast of a different kind.
So let me ask you something. So copyright is artwork. Let's just stay with the artwork. Um, if you have a logo, that's artwork, right?
So yes.
You would trademark a logo though, because like for instance, my logo is trademarked.
So again, another great example of something that can have multiple rights in it. So
Right.
yes, if you're talking about, I don't know, obviously, we've got Disney and Mickey Mouse coming hot into the news because
Mhm.
this year Steamboat Willie, the first Mickey Mouse movie, went into the public domain. But in something like that, such as the Mickey ears as a registered trademark for Disney, it's a registered trademark, and yes, there's a copyright in the design as well. It's both, and logos have those particular rights. So if we're working with a business that has maybe an advertising agency or a independent graphic designer, we want to make sure that the agreements state that what's being created is a work of art, because it is going to be filed under any copyrights are going to be assigned to the to the advertiser. And then we don't mention trademark rights, because trademark rights are about use in commerce, taking that brand and actually using it in commerce. So from that particular standpoint, Frank, if you're thinking about it this way, the copyright's in the art and the trademark is in the branding, and it's perfectly fine. Yeah, logos have multiple rights.
Love it. Love it. I've had IP attorneys before on the show. I don't think I've had it described and articulated like this before. In
Well,
fact,
I know a lot of us are kind of nerdy, and like we aren't very good at speaking of the public unless we're litigators. And they were like, Your Honor, the opposing counsel makes an argument that is just outrage. So I'm like, anyway, no, I'm glad.
yeah, no, it's clear. It's clear now. It's very, very clear now what it is. Well, let's talk about trademark for a little bit though. Let's go into that a little deeper.
You
For
got it.
instance, like I said, I trademark my logo, and I thought, hey, I'm protected, whatever. But leave that on the side. Why is trademark not really a property?
Sure. Because it's a designation, right? When I was describing everything, you'll notice I said patent is a certificate. That's it's a government grant that's in a piece of paper, in a certificate, and it says X, Y, and Z. A copyright is also a government grant, and it gives you a monopoly in what's described, X, Y, and Z, right? So it says to the owner, and it's very blatant. There is a claimant for the patent. There is a claimant for the copyright. There you go. For trademark law, a trademark has a registrant, which means it is someone, and whether it's a person or a business, doesn't matter, someone that has registered this mark. You might not find that what I just said is much difference, but there is a huge difference between the two. We will, in parlance with the court, with the statutes, the word owner does not exist. You do not own a trademark. You have registered your trademark. And what that means is it's kind of plucked out of the public domain for a very specific use. And that use is in the goods and services that are described that you're selling in your trademark application or your trademark registration. With your patent or your copyright, you're the owner, and you can make or create what is described in the patent or the copyright, and you have a legal monopoly over that. That is something that you hold. The trademark is just kind of like I said, a little plucked out of the public domain for a specific use, and it is not considered ownership.
So it's the weakest of the three, is what I'm hearing.
I don't agree with that particular statement either.
Okay.
Because it's not necessarily whether it's strong or weak. I mean, obviously, look, if you tried to make some tires and you called them Apple or Coke or Coke, tires, I know two companies that are going to have some problems with it. You make some tires and you try to call them Barbie tires. I know a company that's going to have a problem with it, right?
Right.
So it's not that it's weak. It's just not a traditional type of ownership, of property ownership, for a trademark. Now, when I'm working with my clients, obviously I want them to put it in their business asset, sheet. I want them to acknowledge the costs that it took for them to get there. I want them to be able to put some kind of value on it as a corporate asset. But it is not traditional ownership the way that you own and anything else. And that includes copyrights and patents, which are considered traditional ownership. So as a matter of fact, if a company goes into bankruptcy,
Uh-huh.
the difference is that the bankruptcy code and is very explicit about treating copyrights and patents as corporate assets.
Gotcha.
And the trademark is not treated as a corporate asset. And therefore, as in terms of how they can be transferred, how can they be assigned, how can they be bought or sold or even licensed, is radically different.
So help me understand something.
Sure.
And I hate to keep harping on this, but it's intriguing to me. What's the value then? Show me what the value is of having a trademark.
So the value of having a trademark registration at the Patent and Trademark Office is one. Should there be a junior user to yours in some similar fashion, you can go straight to federal court and you can talk about those particular issues in a trademark infringement suit should you need to do that, right? And you can say, you could say to the court, we're going to ask for attorney's fees. We're going to ask for, our actual damages, reputational damages. There's a lot of fuzziness and damages in trademark law, but you get to go straight to federal court. And on the small business side, small business defendants don't like being in federal court. So there is that value there of being able to move people off your mark much more quickly than if you were only dealing with the state court, or use, I should say. Two, we do have this system at the Patent and Trademark Office for all of the maligning that we might do these days with the Patent and Trademark Office. It is a centralized office where if you're looking to, to file a mark, the database is there. You can do the research there. I'm not a big fan of the search system there, and I don't particularly use the free search system at the Patent and Trademark Office, but it's there. You can look it up. And every examining attorney who looks at every application is going to be using the same database. So you can look up to see if anybody else has something similar registered to yours, similar trademark, similar goods and services. That's what I like to do with, avoid with other clients. But we also have an administrative court in the Patent and Trademark Office. And if you have a trademark registration, you have the right to file to block any applications that might be similar to yours. So you have an internal system, you have an external system. It's the efficiencies are pretty high when you have that registration.
Interesting. Let's say, well, not let's say, this is true. This is me. Small businesses, right? Is there value in doing any of this stuff? Patented, trademark, copyright. Number one, is there value? And B, when do you think a small business should even think about it? Because you've mentioned some huge companies like Microsoft,
Sure,
Amazon, and all that. I can understand them. But let's say the mom and pop shop down the street.
You know what? Let me tell you about and this is why I always say you need to think about it from the very beginning.
Mm-hmm.
But I have a client that's a cosmetics company, and they have a registration, a trademark portfolio. They're a small business,
mm-hmm.
but they have a naming scheme for their colors. They have a naming scheme for their products. and those get registered. So what does that mean? That means when other cosmetic companies,
Mm,
and I can tell you that with this client, we've sued Kylie Cosmetics.
nice.
We've we've sued OPI, a big nail polish company,
Mm,
and a couple others that, and look, we've gotten some settlement checks, and we've settled cases, and that's what matters. Those
mm-hmm,
companies take their products off the market, and effectively, it's like I said, it's a way to settle a case very quickly. And in some particular aspects, it's, look, a lot of big companies don't do their due diligence properly. I know everybody seems to think that big companies like call their corporate in-house counsel first thing before they breathe in the morning, and that's just not true all the time. So you get issues like this where companies will call their color something, and it turns out it's a registered trademark by some other small cosmetics company.
mm,
You know, that's what happens. I can, most of my clientele are small businesses, and most of my clientele are probably arguing with other small businesses about what their, trademark should be.
got it.
So it's the value is there because sometimes, companies, and look, sometimes companies overstep their bounds as well, but it's because it's about, the branding that's chosen for the business. And if a
Mm-hmm.
junior user comes around and you look at it and you say, hey, that's confusion in the marketplace, then it's confusion in the marketplace.
Yeah, yeah. But yeah, I could see that, especially if you are really passionate about whatever it is you're doing. I could see definitely looking into this just to protect yourself because if you thought of it, someone else might have might think of it as well.
In it's been a couple years, as the, craft brewing has kind of cooled down, but that's also pandemic related. But before the
Yeah.
pandemic, the number of craft breweries that were
Mm,
suing each other for trademark issues was on fire. I mean, it was, I mean,
I can
it was
imagine.
like people coming to independent uses at the same exact time. Total fire.
Awesome. Hey, I'm learning a lot in this interview here, Anthony, to tell you the truth. But tell me something. I'm gonna switch gears a little bit. Give me some big wins, some this is your time to really talk about who you are and who you helped. Anyone that in particular that we may know, the audience may know that you've helped with any kind of copyright infringement or
So
trademark.
let me tell you a little bit about my most controversial um,
Sure.
win,
We
for
we
lack
love
of a better
we
word.
love controversy here.
For lack of a better word. Um, so I was a part of the team that helped an artist named Ken Penders, comic book artist,
Mhm.
um, who signed a contract with Archie Comics, and it was what we call a work for hire agreement. So in other words, you're independent to us, and you're going to make certain works, and those works belong to us because you're going to do it. And very common work for hire agreements are very common, um, because obviously not everybody is making artwork, and in every comic book company they need writers, drawers, inkers, colorists. It's a team that puts together a comic book. Even in today's world, it's a team that puts it together, and even today, it's usually, those jobs are usually separate people. The
Mhm.
problem was that he had created or he had signed a contract that had lots of holes in it, like it was like there were blanks in the agreement. So we filed a suit for copyright infringement because there were new storylines that he had created, new characters that he had created. And again, if the work for hire agreement was specific, I'd say we probably would never have had a case. But because there were blanks in the work for hire agreement, our argument was it wasn't a valid work for hire agreement, and all that stuff belongs to him.
Right.
And so eventually we settled, and he did he did get the rights to the storylines and the characters that he had created. It wound up causing a reboot of the Sonic the Hedgehog comic when it was under Archie Comics. And it was kind of funny going through the Sonic the Hedgehog message board, seeing who was complaining about the reboot and why they were complaining about the reboot of the comics. But look, what that did was it wound up causing a sea change throughout the comic book industry. And I know, like, when I tell the story, a lot of people kind of balk, because what happens now is that if you're in the comic book industry, excuse me, and you are a writer, an inker, a drawer, so you're independent of the actual company, and all the creative jobs really are independent, you're going to be signing a work for hire agreement when you first come on, and you're probably going to be signing a work for hire agreement for every 2 weeks for your payment voucher. And a lot of people think that's really extreme, but you know what? I think it's helpful, because as an artist, you're agreeing, here's the work that I'm doing, and then here's the work that I've done, and it's known to both parties. I'm working on, this title for the here, and here, and this time period. And then I worked on this title for here, and this. Like, yes, there's a little, maybe doing it every 2 weeks is a little excessive, but at least the artists know going in that if they're going to create stuff, it's under the work for hire agreement. I'm sorry, you just can't have a situation where, people are walking around with blank contracts. It's look, Don King used to do that too with his boxers. Like he had contracts, agency contracts with like blanks in them, and then he would go fill them in. So, like, from a public policy standpoint, like we just, we can't operate like that. So, it might be a little restrictive on the artist side, but you're not, if you're being hired by a comic book company, chances are you're not doing those things independently anyway.
Right. Wow, we met Don King. That's a name from the past.
It is a name from the past, but you know what? It was one of the deans of my law school represented one of the boxers that sued Don King. And yeah, so I was visiting the school. I was visiting my law school years ago, and I was telling her about this case. She goes, "Oh yeah, it's like when I represented, I forget what the boxer, against Don King. Same thing. Blanks in the contract." And I'm like, yeah, blanks in the contract.
Interesting. Now, your practice is in New York, right? Upstate New York.
Whoa! Let's not. Whoa! Let's talk upstate. Upstate. Come on, Frank. Come on.
Well, not really upstate.
I mean, I'm north of New York City, but like, whoa, not.
This is a great banter, because I was born in the Bronx. So we always call anything in Westchester upstate.
I mean, I guess technically that would be true, but I don't know, man. I hop a train, I'm into New York City in less than an hour. It's
That's
not
true. That is true. That is
true. Our office is in the city of Rye, New York. Okay. And it's I'm not sitting there now. I'm currently sitting at home in the recording studio. But Rye is a beautiful town, and it's always a pleasure just kind of go there and rest. When I first hung the practice shingle, I did it in White Plains, and I quickly learned nobody cared that I was right down the street from the federal courthouse, and I just found a better building, a better environment, just 5 miles away. So. I do really enjoy, the area.
Now, you could represent anyone within the United States, correct?
So on the application side, yes, it's not a problem to represent anybody anywhere in the United States. We even represent people and businesses in United Kingdom, France, the Netherlands, South Africa, China, India. So we do have a worldwide reach despite our small stature.
Awesome. Awesome. And so now what's the website again?
Sure, you can just my last name, vernalaw.com, spelled
Hmm.
Verna.
Okay, awesome. Are you doing anything on social media that I can point people to as well? Or?
Yeah, I believe if you really feel like digging up, you can find me on Facebook. Just type Anthony Verna IP lawyer into Facebook. You'll find me. Verna Law PC on the TikTok. That's right, on the TikTok. You'll find me as well.
You
Um,
use TikTok, don't you?
I
Oh,
do
wow.
use TikTok. It's kind of an experiment more than anything. My wife is the TikTok celebrity between the two of us, so I kind of still am
Okay.
dipping my toe in
Yeah.
and trying
Wow. You're further than me because I don't even TikTok.
it.
So is there now I know you litigate and all that stuff, but you also help people with registering their
Yes,
trademarks and patents and all that kind
yes.
of stuff. Okay, cool, cool, cool. Is there any reason why you would outsource that? Like, is it because you're busy or whatever, or
The
you just
only I would say this. The only thing we probably are not touching is if you come to us with a chemistry patent or probably a plant patent, I don't know that we would outsource. I just think we would make a referral. Other than that, I mean, we're here.
fair game? Okay, awesome. This has been great. I mean, I've learned a lot about
But thank you, sir.
patents and trademark. I'm glad you went into that with the trademark because I actually thought I had something when I trademarked my logo. Now I'm thinking maybe I need something else. But anyway, we can talk about that some other time, maybe when we come off of this thing. Um, Before I let you go, I know you're very, very busy, man. Before I let you go, though, is there anything I did not ask you that you think would benefit the audience?
You know, I think the one question that a lot of people seem to forget is what do I need to think about for my business, my small business? And I would just say, look, a having a chat with someone is probably helpful because every business is different. Every
Mhm.
business cares about their products differently. Every business cares about their branding differently. Everybody cares about anything they make new differently. So have the chat, but have the chat before you need to have the chat.
Mm.
Have that chat long ago. Pick up the phone and call. Like for us, if you wanted to call me, we'll chat anytime. All right, what's your business model? What's your business plan? Those particular issues are important.
Mhm.
So, yeah, that to me, the timing, the very beginning, why? Because. I mean, really, the because is um that's the answer. Like if I want to tell you, it should probably be me who says, you know, maybe that isn't yeah, that's what you're branding your company as, but it's not really a trademark. You know,
Mhm.
it's probably better if I say it than you, because if you're wrong
Mhm.
and then something happens, it's really hard to put the toothpaste back in the tube. It
No too.
really is. And especially and on the patent side, if you think, I my wife and I were at a conference a couple weeks ago in Seattle, and there was someone who was like, I don't know, we don't really think that it is, and I'm listening to what they say, and I'm like, I I disagree with you.
Mhm.
I think you've got something here, and I think you're really harming your business value if you don't at least consider having a private phone call. So
Mhm.
have that phone call with us early, and let's see. If you don't know, the worst I could tell you is, yeah, don't spend the money.
Right.
And
Right.
the best I could tell you is, here's how we protect your business.
Yeah, having the conversation is key. It is key. And I appreciate you telling me that. I'm glad I asked that question. But yeah, this has been really, really fun. I want you to stick around here before you go. But I am going to put an end to this episode right now. This has been Frank Deming, the local business guy. You've just been blessed by the great Anthony Verna. All right, everyone, until next week, peace out.
Thanks for listening to another episode of Marketing Solutions for Local Law Firms, the podcast that provides you with all the latest digital marketing tools, tips, and strategies you will need to implement in order to stay ahead of your competition. If you would like to know more about the topic we discussed on the show today, reach out to Frank and his team at 888-416-7752 and schedule a discovery call with one of the marketing consultants. If you'd like to be a guest on our show, send an email to podcast@lbmsllc.com and we will put you on the schedule. With that being said, until next week, make it a successful digital marketing day. Peace out.